Have you ever thought about how many contracts you've signed in your life? Hi, I'm Simon Dippenaar and I'm an attorney. If you're an adult, you've entered into a contract at some point. If you rent your home, your lease is a contract. If you have a job, you have an employment contract, or you should have. You probably did not draw up these contracts yourself. The property owner or the agent would have drawn up the lease agreement. Your employment contract was provided by your employer. But you may need to draft a contract for your business or services to your home, or you need to review a contract you may have been asked to sign. Now, what are the key considerations you should bear in mind to ensure the contract is effective? A contract is a formal name for an agreement between two or more parties that creates a legal obligation on the parties. It is in effect a legally binding promise. A contract carries repercussions for failure to keep a promise you have made formally in law. Contracts help to regulate business relationships by defining each party's expectations and obligations. A contract obligation is a legal duty to perform certain activities, and the other party has a corresponding duty of performance. What are the various types of contracts? I won't go into detail in this talk, but the contracts you are most likely to enter into are sales contracts, lease contracts, employment contracts, service contracts, and non-disclosure agreements. Of course, a contract may be drafted to cover any set of circumstances, but these are the contracts that you are most likely to encounter. Well, what makes a contract a contract? I've said that it's a legally binding promise, but to be legally binding, it must contain certain elements. Firstly, the offer. Without an offer, there is no basis for a contract. An offer is a proposal made by one party to another with the intention of entering into a contract. Then acceptance. Naturally, the party being made the offer must accept it. Without that, the unconditional agreement to the terms of the offer, there is no contract. Then consensus. Consensus means the parties agree on the essential terms of the contract and are willing to be bound by it. They consent to the agreement. Next is consideration. This is the legal term for value exchange between the parties, such as money, goods, services, or a promise to do something, or refrain from doing something, as in a non-disclosure agreement. Next is certainty. This ensures the material terms of the contract are clear and unambiguous, so all parties know what their rights and obligations are. For example, if you contract to buy an iPhone 14, you want to be sure you're provided with an iPhone 14 and not an older model. If the contract only states iPhone, there is no certainty. Then it's capacity. All parties entering into a contract must have the legal capacity to do so. This refers to being of legal age to contract, as well as having a legal competency to understand the nature and consequences of the contract. For example, someone who is comatose may not be considered legally competent to enter into a contract. Then we've got possibility of performance. The rights and obligations created the contract must be possible to perform. Then legality. The contract must have a lawful purpose and must not contravene any statutory provisions or public policy. It must comply with all applicable laws, regulations, and industry standards. Then we have formalities. Some contracts have formalities prescribed by law or stipulated by the relevant industry professional parties, such as registration requirements. For example, certain contracts in South Africa must be in writing to be enforceable, such as long-term leases. While these are the essential elements needed for a contract to be enforceable, they don't in themselves render a contract effective. Now, here are some considerations that help make a contract watertight. The contract should be written in clear and understandable language. Ambiguity or vagueness can lead to confusion and disputes. The parties involved in the contract should be clearly identified with accurate and complete names, addresses, and contact information to avoid any misunderstanding. The purpose and scope of the contract should be clearly defined, showing what the contract aims to achieve, the specific rights and obligations of each party, and any limitations or exclusions. The terms and conditions should be outlined, including details such as payment terms, delivery or performance requirements, timelines, quality standards, and any specific provisions. Risks and responsibilities should be fairly allocated between the parties. This may include warranties, indemnification, limitation of liability, and insurance requirements. The mechanism for resolving disputes should be also specified. This refers to provisions for negotiation or mediation, for example. Termination and breach provisions should be included, including the rights and obligations of the parties upon termination and any consequences of breach of contract. If relevant, provisions should be included to protect confidential information and trade secrets, specifying the obligations of the parties and safeguarding and restricting the use of this information. The governing law that applies to the contract should be specified along with the jurisdiction where any disputes will be resolved. If all parties are in South Africa, this is unlikely to be necessary, but it's important if the parties are located in different jurisdictions. And what about verbal contracts, you may be wondering? In South African law, verbal contracts can be binding and enforceable with some exceptions. I mentioned that lease agreements and contracts for the sale of immovable property must be in writing. However, a written contract is generally a good idea, even if not legally required. It ensures clarity, evidence, and easier enforcement of the terms. At Simon Dippenaar Associates ST Law, we speak plain English and avoid legal jargon. If you need help drafting a contract or you'd like us to review a contract you are entering into, please give me a call on the number in the signature below.